Today we have Judge Edison with us. He's in the Southern District of Texas. Judge, could you go ahead and tell the audience a little bit about yourself in case they're either law students or new lawyers who aren't familiar with you?
Absolutely. I grew up in Houston, Texas, left for college and law school, went to Dartmouth College and the University of Virginia for law school. Always knew I wanted to be a trial lawyer. Started my career at a big firm in Houston as a trial lawyer. I was there about 15 years or so. Then, with a couple good friends, we started a litigation boutique that was called Edison, McDowell, and Hetherington, handling all sorts of litigation, both on the plaintiff side and defense side. And then 8 years ago, the honor of a lifetime, I got appointed to the federal bench. And I always like to say that, and it's true, I loved my job as a trial lawyer, thought it was exciting, challenging, rewarding. Thought I had the best job in the world, but now I truly have the best job in the world. Love, absolutely love what I get to do every single day.
That's awesome. Uh, I wanted to do this interview mainly to cover one subject that has become more relevant since I joined Daily and Black, and I've joined some mediations, but when I was an intern with you, I got to see a ton of mediations. And so now that I have some new context, I recognize you're probably the king of mediation. And so I kind of wanted to get your opinion on pointers for for mediations and how to play them out. And so my first question is, if you were coaching a young plaintiff's lawyer for mediation, what would you say and what would you tell them to focus on?
Well, first and foremost, my advice would not only be for young plaintiffs' lawyers, but young lawyers in general, really all lawyers. I don't think there's necessarily for plaintiff, defense, young, older. I think the biggest advice I would have for lawyers is be prepared. Know your case. Know the strengths, know the weaknesses, know the law. I'm always shocked how many people go to mediation and just don't understand basic facts or the law. You got to understand your case if you're going to be effective. And I think it's important for a lawyer to think in advance. Hey, what do we really want? What's our minimum that we're going to ask for, that we're going to demand, that we're going to offer, and have an idea that you really think about how this is going to play out. And then the final thing that is imperative, and unfortunately, a lot of people don't do this, is talk to your client. Have your client prepared. Don't go into a mediation if you know, hey, I think we're going to get 25,000, where your client for some reason thinks there's going to be millions and millions of dollars that are being thrown around the table. So I don't want to say temper your client's expectations, but have an honest, forthright discussion with your client as to what to expect. Because I spend a lot of time at mediations, really trying to talk to clients, saying, "Hey, you know, you're not going to get $1 million in this case. That's not, in fact, even if you go to trial and you hit a grand slam, you win everything. That's not going to happen. So be prepared and make sure you have discussed the case thoroughly with your client ahead of time."
And that kind of brings me into another question I wanted to ask. What happens when a lawyer fails to prepare their client, manage their expectations?
Well, a couple things. One, a lot of times will doom the mediation. I mean, if a client goes in thinking they're going to be putting $1 million in their pocket, and it turns out that they're limited at best to $25,000 recovery, that usually doesn't go very well, as you would expect. The best thing that happens if someone comes unprepared or doesn't talk to their client ahead of time, it's a pain in the rear end for the mediator because you got to spend a lot more time up front trying to lower expectations, try to explain things, understand things. So it delays the process at best, and at worst, it really hurts the underlying or overall relief that a plaintiff gets or defendant has to pay.
Speaking of pain in the rear for the mediator, another thing I saw following you when we shadowed you was it seemed as though a lot of attorneys would not want to be honest with the mediator about the best they could do. Could you speak on that? And is that a valid? I think they have a concern that you will pull them beyond that. And so, can you speak to that? Is that a valid concern? Are there strategic reasons why you wouldn't want to be honest with the mediator? Or do you think, at the end of the day, they're wasting time by doing that?
Great question. And let me say this. Overall, mediation is an art, not a science. So Different people have different approaches. My mediation style is different from others. That's not to say that they're ineffective, that I'm effective. It really varies from person to person that goes away. I understand why some people don't want to tell the mediator what they really have. And there's a concern, for example, if you're on the defense side, hey, mediator, I have $100,000. A lot of mediators go, okay, I know they have at least $100,000. And while someone is trying to communicate the maximum amount they're willing to go, the concern is that that is just the amount the mediator will start at, and that the mediator won't be trying to fight for them or try to be willing to throw that money on the table automatically. So I totally understand that. And in all honesty, as a practicing lawyer, I shared that concern. But at the same time, I always think it's important. You gotta let the mediator, whether it's a judge who has some experience or you're paying the mediator, you gotta put your confidence, faith, and trust in the mediator. And that's why, at least I always tell people, hey, what are you willing to do here? And if they say, Judge, 100,000, I respect that. I said, fine. I'm not going to ask you for a penny more. I'll see if I can get it done at that and not a penny more. I think some people are surprised at that. Why won't he ask for more? Hey, if you tell me that's all you got, I'll believe you. So I guess in a nutshell, fully understand why lawyers would be reluctant to sort of honestly say how much you have either to give or that you're willing to take because you're worried that that will just be utilized by the mediator in a nefarious way, in effect, to either get you to go higher or get you to go lower. But I was confident, hey, here's the number. Mediator, don't fool around, play around. That's what I got, or that's what I'm willing to take, and I'm not going to lie to you or go lower or higher. That's what it is.
Great. The next question I have is, what are common mistakes that you see young lawyers in particular make that are actually helping the other side?
It's funny. The first question you asked was, what are the tips I have for young lawyers? And the mistakes are exactly the things I said, the tips. I said, tip number one, be prepared. Biggest mistake. People come not in prepared. They don't, I had a mediation recently where someone said, Judge, we need our attorney's fees. We're entitled to $100,000 in attorney's fees under the Declaratory Judgment Act. Okay, well, that's great. Well, in federal court, there is no such thing that awards you attorney's fees. So that isn't thing. So their whole big argument was give us 100,000 in attorney's fees when there was no legal support, zero, zilch, nada, nothing. You got to be prepared. So it's really the flip of everything I said a few moments ago when I said, younger, newer lawyers, as I say, need to be prepared, need their communications with their clients. The biggest mistakes are people not being prepared and not having those full, frank, and open discussions with their clients before a mediation starts and sort of looking to me and say, Judge, help me out. I need you to explain what's happening in the case. I'm happy to do it, but that's sort of the lawyer's job is to make sure that the client has a good understanding of what is happening and what to expect when you start the mediation process.
All right. Now, this next question, you might just cite to your previous answer for this as well. What separates mediations where the defendant actually moves real money from those where they hold firm all day? And what sort of information or framing most often causes the adjusters to exceed initial authority?
You know, um, my honest answer to that is, boy, it depends on each and every case. Each case is unique. So I don't think I could just say uniformly, hey, are there certain cases or individuals that won't move or willing to offer money? There's a whole bunch of factors that go into it, right? It might be, say you're on the defense side, boy, I think my case stinks. I'm willing to put in money. It might be, oh, that my client doesn't want to pay my attorney's fees. It might be you're getting to the end of a quarter, a company's trying to wrap up their books and wants to give, rid of this matter. There's a whole number of things that can get into it, both on the plaintiff and defense side. So I think it is very, very, very dependent, case dependent. I do think one thing that I always find interesting in the process is when you get parties close, even if they have had firm lines, I won't pay more than 500,000. I won't take less than this. Once they get close and you start saying, hey, let's put a little more money or take a little less, people seem to be more willing to do that. It seems to me. Can I also make one comment there, Thomas, real quick?
Yeah, absolutely.
I think one of the most interesting challenges for mediation these days is that fewer and fewer trial lawyers are getting trial experience. Fewer young lawyers are getting trial experience. When I was a young lawyer, I had a lot of small cases. I got my bosses gave them to me. I could make mistakes. I could fall down, brush myself off, and get up. Nowadays, so few cases go to trial, younger lawyers are not getting trial experience, and it really creates a problem. And where that equates to mediation, and this happened to me, and which was a fascinating case, I had a case that was going to trial on a Monday. They mediated before me on Friday. We were at the Galveston Federal Courthouse. And obviously, I'm not going to talk any details, but basically, the plaintiff, after a full day, the plaintiff says, Judge, we're not going to take less than $1 million. $1 million is the number. We're not taking less than a million. Okay. And the defense lawyer calls me in, and the defense lawyer says, Judge, I just got to be honest with you. We're not paying more than a $500,000. We are not paying more than a $500,000. That is a line in the sand. Okay, I respect that. We spent a full day. I go tell the parties, we're at an impasse. Good luck on trial. Have a great time. So I get in my car in Galveston, driving back up to Houston, and I'm not even over the causeway, right? 10 minutes from the courthouse, and my phone rings. And it's the plaintiff's lawyer. And the plaintiff's lawyer says, Judge, we got to settle this case. We're going to trial Monday. I said, what do you want me to do? You said you're not going to take less than $1 million. They're not going to pay $1 million. I promise you that. Oh, you got to make a mediator's proposal. You got to make a mediator's proposal. I said, well, and what I'm not making this up. While I'm talking to that lawyer, I look down, I have a call from the other side. And the defense lawyer says, Judge, you got to settle this case. We got to settle. I said, what do you want me to do? You said you wouldn't pay more than a $500,000. They're not taking a $500,000. Judge, you got to make a mediator's proposal. You got to make a mediator's proposal. So I get on the phone with both of them, and I thought for a minute, this is crazy. And it's not going to surprise you what my mediator's proposal was, but I made a mediator's proposal at $750,000, split the baby, both sides accepted by the time I pulled into my garage in Houston. And I was always stunned by that, but I think it is one of the impacts that this lack of experience that people have. They don't know how to try cases. And as a result, I think people are much more inclined to settle them, maybe right before trial and the courthouse steps. But I think that drives a lot of people to settlement. And I always love telling that story because it's a good one.
Yeah. Well, that's one of the reasons I was considering going and being a prosecutor for a while because I wanted that trial experience so bad before I went civil because I feel like you can't fully represent your client to your best ability if you're scared to go to trial because you've never done it before and things like that. But anyways, overcoming that with,
That's exactly right. You
yeah.
you have you have hit the proverbial nail on the head.
This is another one I've heard. Should you keep certain information in your pocket for when the mediation stalls, or is full disclosure early more effective?
So, once again, judgment call. Certain people will tell you different things. My view is you should always keep your mediator. You got to trust your mediator. Your mediator is your intermediary who's going to help you try to get the deal done. So I never think you should hide things from the mediator. I think it's important if you got some good ammunition, tell the mediator, hey, I got this great stuff. Don't say anything now. I'll decide if I want to say it later, but don't say anything now. Because I think at a certain point, a mediation gets a little bit of momentum. And if you get to a certain point, and you say, oh, by the way, I got a killer argument I want to raise, 6 hours into the mediation. I don't know. I think it loses some of its power and its emphasis. And so, at least if you tell the mediator up front, it's sort of out there and the mediator's thinking it, considering it. But look, case by case basis, there might be a situation where you might have know something. I remember we had a personal injury case where the defendant had some photos. The plaintiff said they couldn't lift anything and they had him working out, with weights. And I always thought, why are we keeping, the judge, don't tell him now. Why not? This seems like the best, this is, if it's so good, maybe this will push it right now. They wanted me to hold on to it. Not sure I agreed, but I respect everyone's opinions, how to handle in due course.
All right, Judge. Well, this is going to bring me to the last question. Do you have any tips or principles for lawyers just starting their career?
Absolutely. I have a lot of tips for young lawyers starting the career. First and foremost, my biggest tip is enjoy what you do. I think being a lawyer is the greatest profession. I've absolutely loved it. I'm always dismayed in a little bit when I hear people who don't like what they do. And look, certain kind of work is for certain people, other kind of work for other people. find what you enjoy. I think it was Mark Twain that once said that it ain't work if you enjoy going in every day and doing it. Something like that. I haven't, that's not the exact words, but find something you enjoy and don't do it simply because of the money. I'm amazed how many times people leave firms sometimes and find something they enjoy and the money follows. But always, you'll be much happier. Find something you like to do. And if you stop like something, if you don't like doing something, then move on. So that's number one. The other, a few things, and I know I've had you, Thomas, as an intern and a law student in one of my classes, so I've said this, but there's nothing that beats good old hard work. I think too many people in this day and age think that they're going to get a lot of clients or a lot of respect by not doing things. So you got to work hard, but there's also nothing that beats being friendly, being nice. You don't need to be a jerk. And for some reason, newer lawyers who join the profession think they got to do Rambo and yell and scream and be bombastic and mean. That is not the case. You can kick people in the rear end in the courtroom and be the nicest human being possible. And I always found one of the greatest compliments I ever got was a couple people who hired me after I had sued them and been on the opposite side of a case. And they said, "Man, boy, we respect you. We want to hire you." Um, and there's no reason to be a jerk to the other side. One, I don't think it helps you in the case. And two, it's just the wrong thing to do. So you can vociferously represent your client and make sure your client's interests are, are represented very, very well without being a jerk. So I guess in a nutshell, enjoy what you do, work hard, don't be a jerk. And then I know this sounds sort of silly and sort of simple, but take vacations, do things other than the law. And, I always am one to say, hey, your boss is never going to walk in and say, hey, Thomas, you need to take a week off vacation. You got to do it. But it's important. One, I think it makes you more well-rounded. It gives you new perspective. And plus, it makes you feel better. So work hard, but you also have a life outside of the law, and you can do both. I'm always one of the greatest stories I always tell is I was going with our daughter was younger. We were going to Disney World, and my wife's like, "You cannot take your phone into the to Disney World because you'll." I mean, I would. I just look at it all the time. So I had a bounce back message. I said, okay, in the morning I'm going to look at my emails, and at night, but I had a bounce back message that said, thank you for your email. I'm at the happiest place on earth, the Magic Kingdom at Disney World. I'll get back with you, early in the morning or late at night. And I get these messages from people, hey, Edison, call me. I have a new case. I need to talk to you now. And then they get the bounce back. And then their next response was, don't worry about it. Call me next week. That's great. And I actually thought I was getting more business and more people were calling me more because I'd sent that one reminder email. But it's important. You work hard, but at the same time, you got to get out of the office and there never lose track that there are personal things that are very, very important outside of work. And I think there's no reason they can't coexist. They should be able to coexist, and you need to make sure they coexist. I knew a lot of people in the profession who had candidly didn't have good relationship with the kids or their own kids or marriage. And when our daughter was born, I promised my wife every day that I was in Houston, I'd have dinner. With the family at a certain time. And if I had to go back to the office or work later, I would. But I had a certain time. And the first time this came up, I was at a meeting at a client's. I'm looking at the watch thinking, uh-oh, this has gone long. Finally, I said, guys, I apologize. I got to leave in 5 minutes. We just had this baby. I told my wife that I'd do it. And, I'm happy to come back. And two people at that meeting came up to me and said, we respect that. I wish I'd done that. If I had, I'd still be married. And so you can you can have a good family life. You can find things you enjoy and are passionate about outside the law, and be a highly successful lawyer at the same time. Don't ever forget that. And if anyone tells you that's not the case, tell them to take a long walk off a short pier.
That's one of the expressions I will take with me the rest of my career, along with I was born at night, but I wasn't born last night. So
I
thank
use the same expressions all the time. So what can I say?
Yeah. Well, thank you, Judge Edison.
You
I
can't
really
teach an
appreciate.
old dog new tricks, as they say, Thomas.
Yeah, yeah.
So
Well,
thank you
thank
very much. It's been an absolute pleasure.
Yeah, and I just want to say, thank you for. I hope one day in my career I'm able to do what you've done for myself and so many other law students. And so I really sincerely appreciate you taking the time for this. Yeah, and then stick around. I'll end the recording and we can say proper farewells after that.
Well, thank you. And I'll say this, one of the most rewarding parts of my job, and I say this in all sincerity, is the opportunity to work with you and other law students to sort of see you develop. The world is your oyster. It is limitless, and wish all the best to you and all the other newer, younger lawyers out there. Incredible success in the future. So, thank you very much.